Contracts are an integral part of our daily lives, from buying a house to accepting software terms and conditions. But what makes a contract legally binding, and how does the law interpret these agreements? Today, we're exploring the fascinating world of contract law, with a special focus on the Benefit-Detriment Theory. At its core, a contract is a legally enforceable agreement between two or more parties. It's essentially a promise, recognized by law. While contracts can take many forms, they all share common elements that make them valid and enforceable. The key elements of a contract include an offer, acceptance, consideration, and mutuality. An offer is a promise to do or not do something. Acceptance is a clear agreement to the terms of that offer. Mutuality means all parties understand and agree to the basic terms. But perhaps the most intriguing element is consideration. Consideration is what distinguishes a contract from a mere promise or gift. It's the value that motivates parties to enter into an agreement. This is where the Benefit-Detriment Theory comes into play. The Benefit-Detriment Theory states that consideration exists if the contract either benefits the promisor or causes a detriment to the promisee. This theory expands our understanding of what can constitute valid consideration in a contract. A landmark case that illustrates this theory is Hammer v. Sidway from 1891. In this case, an uncle promised his nephew $5,000 if he refrained from drinking, smoking, gambling, and swearing until he turned 21. The court ruled that the nephew's forbearance, giving up his legal right to engage in these activities, constituted valid consideration. This case is significant because it showed that consideration doesn't have to involve an exchange of money or tangible goods. The nephew's detriment, giving up certain behaviors, was enough to make the contract enforceable. Contracts can take various forms. Express contracts clearly state all elements, while implied contracts have no express terms. They can also be categorized as unilateral or bilateral. In a unilateral contract, one party makes a promise in exchange for an act. The contract is formed only when the act is performed. For example, a company offering a reward for finding lost property. Bilateral contracts, on the other hand, involve both parties exchanging promises, forming an enforceable agreement immediately. An example would be a contract where one party agrees to deliver goods and the other agrees to pay. It's important to note that contracts don't always have to be in writing to be enforceable. Oral contracts can be legally binding, although they may be harder to enforce. However, certain agreements, such as those involving real estate, must be in writing under the statute of frauds. Understanding contract law and theories like the Benefit-Detriment Theory is crucial in today's world. Whether you're a business owner, employee, or consumer, knowing what makes a contract valid and enforceable can protect your rights and interests in any agreement you enter. Remember, a legally binding contract requires clear terms, valid consideration, mutual assent, and compliance with any statutory requirements. By keeping these principles in mind, you can navigate the complex world of contracts with confidence.